rise. The justices of the Appellate Division, Supreme Court, First Department. Be it ye, all persons having business in the Appellate Division. Your hand, your attendance, and you shall be heard. Please be seated.
Good afternoon. Good afternoon, everyone. Welcome to the Appellate Division First Department. We have some over 8 hours of argument this afternoon that has been requested. So I'm about to call the calendar, and I'd like to remind you all to please ask only for the time that you need. We have the briefs, we have your records, we are fully familiar with the facts of your cases, so please, very important for you to keep that in mind. And of course, if we have any questions, we will ask them even if the red light goes out. Okay, with that, People versus Gideon Godsent. 6, 2, and 6. Davis versus Davis. 5, 2, and 5. W. Children is submitted. McMillan versus Marengo. Uh, 5 and 1 and 5. Tobin versus Peter off the corner. Submitted. People versus Raymond Godfrey. 6, 2, and 6. Star Indemnity versus U.S. Adjustment. 6, 2, and 6. 231st Riverdale versus Star Home. Submitted. Morrison versus New York City Department of Corrections. Submitted. White versus New York City Transit Authority. Submitted. Shahada versus Those Awesome Guys. 5, 2, and 5. People versus Taikawan Anderson. Submitted. Kirby Forensic versus Sammy M. I didn't hear you. Please speak up.
5 for Kirby and 5 for the district attorney, also.
I will give you four, 3, and 7. And is the district attorney asking for rebuttal also?
No.
Okay, so, and I'll give Kirby 2 minutes for rebuttal. I'll give Kirby 1 minute. So that is 4 and 1 for Kirby, 3 for the district attorney's office, 2 for the district attorney's office, and 7 for the respondent. People versus Juan Rodriguez. Submitted. People versus Pedro Flores. Submitted. Summit Development versus Hudson Meridian.
Summit Appellate 7-3 requested, please.
Hudson Meridian. Okay, so you're the only one here. Do you want to submit?
I'd like to argue.
Okay, I'll give you 2 minutes and submission. People versus Victor Hernandez. Submitted. Langomas versus City of New York.
Appellant requests 6-4.
6 and 4. And the respondent? There's no respondent here, sir. Do you want to submit?
In that case, I would want 3 minutes to respond to questions that the court may have.
Okay, I'll give you 2 minutes in the submission. If we have more questions, we'll ask them. People versus Tavon Johnson? 4, 1, and 4. People versus David Malowich? Sorry, speak up a little bit.
6 minutes plus 2 for rebuttal.
I'll do 5, 1, and 5. Strichuk versus Hirkoian?
Respondent requests 6 minutes.
5, 1, and 5. And James versus Allen? I'll give you 7 and 2 and 7. First case for argument, People versus Gideon Godsent.
Good afternoon, Your Honors. Hunter Haney for Godsent Gideon. While the pretrial errors in this case present several bases for reversal that we're in no way conceding, I'd like to cut to the heart of this matter and address the weight and the hearsay points. Mr. Gideon's convictions hinged upon the testimony of a complainant that lacked a shred of consistency and was tainted by an undisputed motive to fabricate and desire for profit. When complainant learned that Mr. Gideon was a sex offender, she became determined to have him removed from the building at all costs, and her cobbled together story cannot withstand scrutiny. Time won't allow me to address every possible inconsistency and reason for doubting her testimony, but just to touch on some key points here. First, the internal problems with her account. Her complete nonchalance about the incident throughout her text messages.
Counsel, before too much time passed, she was already, first of all, she fought with the guy to get him out of her room. And then before too much time passed, she texted her friend. Then she called downstairs. There were things that she did that were very close in time to when the incident happened.
Her text messages, just to start with those, were laced with laughter and completely nonspecific statements about how Mr. Gideon tried to touch her and concern about what he might do next. But again, there was no inkling of any sort of sexual assault in the text messages, and this continued until the next day when she was most concerned throughout the morning with going out for entertainment. Her conduct just simply wasn't consistent with someone who had just been assaulted. And despite being given ample opportunity to provide details to many authority figures, her account was never really specific later on in that next afternoon either. And beyond just the mere internal problems with her account, there were numerous key inconsistencies with other testimony throughout the trial. From the incident in front of the T-Mobile store, which was refuted by her friend, who was reportedly the one getting her phone fixed, remembered nothing about the incident, seeing Mr. Gideon outside of the store. The claim that police...
So I'm sorry, I just want to back up a little bit because I just found it. With regard to the text message, for example, this happens around midnight. Now, if casual to me would be she goes back to bed, but that's not what she does. She texts somebody at 12:26 in the morning, 12:26 in the morning, and she says it's the girl down, she didn't just give her name, so this isn't someone who she was very close to. It's not the kind of relationship where she could just call and say, hi, it's so-and-so, and the woman, she had to identify herself by name and by description of where she lived. So this was not, I doubt, that does not sound to me like a casual rendition of what happened when you're calling some person that's barely an acquaintance at 2:30 and 12:30 in the morning.
Both of their testimony establishes that they were friends, that they became friends at the shelter. And in addition to that, they continued to text throughout the entire morning until 4 in the morning when the fire drill happened.
I thought you had indicated that they were laughing, that it was not a very serious conversation. I thought that some of the texts that the complainant said was, you know, he comes to my door, now he thinks he can knock anytime. He thinks he can walk in and touch me. I'm going to report him. It seems he only attacks women who look lonely. So I don't know if that would be an indication that there was no statement that he tried to touch her or do something. There was.
There was no specificity to that statement. That was as specific as it got. Touch me, tried to touch me. Again, you know, and I see the lights on, so I want to make sure I get a chance to address the hearsay point. But the
You
evidence
still
was
have 2 minutes with.
the evidence was not restricted to the text messages, and the inconsistencies were not restricted to the text messages. There were numerous bizarre things about this case, including the opening of the window after the incident, the allegation that police said she should have screamed, even though the police were trained in.
Well, that was that police officer. The other police officer who went and arrested him didn't have that impression, didn't create that impression at all. But why don't you get to the hearsay?
Absolutely. So clearly recognizing the infirmities in the complainant's account, the prosecution, in advance of trial, sought to admit the text messages and the subsequent reporting to attempt to bolster its case. But as my adversary nearly concedes here, these statements in no way qualified as excited utterances, prompt outcry, or under any other hearsay exception. And because these statements—
Why aren't they prompt outcries?
They're not prompt outcry for 2 reasons, Your Honor. First, the prompt outcry exception only applies to jury trials. That's from page 42 of my respondent's brief, and in my brief as well, at pages 75 to 76, we cite numerous authorities saying that the purpose of the exception is to rebut the adverse inference a jury would draw if not presented with proof of a timely complaint. Here we have a bench trial. But even if this was a jury trial, the statements were not made at the first suitable opportunity. You have a text message here. This is just the first statement, by the way, and all 4 statements were admitted purportedly under the prompt outcry exception. The text message is 20 minutes after the complainant made a phone call to someone else. The complainant was an adult who was aware of the need to promptly report, as she testified at trial. And again, even if that statement could come in under the prompt outcry exception, there was no need, besides bolstering, to admit the others after that. So that the statement was by no means, none of the 4 statements were admissible under the prompt outcry exception.
Thank you.
Thank you, Your Honor.
You have some rebuttal.
Good afternoon, Your Honor. It's Vincent Revelisi for the people.
Counsel, why don't you start with the excited utterance, prompt outcry, those statements that were made and permitted into evidence?
Yes, Judge. There were 4 separate statements. The first was very soon after the event. The victim was in her room after having been attacked. The last contact with the defendant was 12:09 a.m., and her text message was 12:26, her first text message. That's just 17 minutes, and during that time, she also called her ex-boyfriend, the father of her child, to tell him what had happened. So this was a rather quick report, the first one. And at the time, the defendant lived across the hallway or down the hallway from her, and she was afraid. She couldn't see through the peephole. She didn't know if he was still out there or when he would be. So the excited event actually continued for her for quite a while.
What about what counsel just said with regard to the jury and why this prompt outcry is for the jury?
Well, it's for a fact finder, and usually that is a jury, and in most of the cases it's going to be a jury, but a judge still has to find the facts, and facts that are relevant to a judge or to a jury would be relevant to the other as well.
And is there less potential for a concern or abuse with a bench trial than a jury, or not?
Well, I think there's less potential that the judge would be prejudiced by hearing the evidence than a jury. So if anything, it would be less of a problem here. The judge is less likely to hold it against the defendant when she hears these things and to just consider them for the purpose that they actually apply for.
Except you had 4 statements here.
Yes. And if If any person were the judge, they wouldn't necessarily have to admit all four. It's a matter of discretion. In this case, the rationale was that the complainant was under the emotion of this until the defendant was ejected from the place where she lived. So until he was arrested, she was still very upset that he lived there and she saw him there after what had happened to her, and nothing had been done about it. The first police officers didn't do anything about it. The staff.
So you're saying, I can't remember how many days it was, or so 48 hours later, however many hours, you're saying that's still enough for a prompt outcry?
It was a little less than 48, but it was more than 24 from the beginning to the last statement. It was, well, actually, it wasn't more than 24, but it was many hours. It wasn't 1 or 2 hours. It was many hours. And in this case, because of the constant presence of the defendant, it was not unreasonable for the judge to find that she was still under the excitement of what had happened because he was still there.
Excitement, maybe that's not the word that you want to use, because it was not an excited utterance. I don't see how you have an excited utterance 4 hours, over 24 hours later.
To the extent that that would be the case, if the judge had over admitted too much evidence, it would be cumulative to what was certainly admissible. The first statements to the friend and to the staff very soon after the event really had to be both excited utterances and also possibly prompt outcry.
She had, so I don't think it's your best argument to argue excited utterance when she had time to contemplate this and talk to somebody about it and discuss whether or not it was a good idea to report him. That you're not supposed to have contemplation in an excited utterance.
The first statement, though, when she texted the person that she had to identify herself, that really was under the excitement of the event. She only talked about whether to report it after she already had said what happened, that he had already come in and assaulted her. I don't think she used the word assault, but she definitely said that he had moved upon her, and that's when she then contemplated whether to report. So she was already telling the person about it when she said something about reporting. In addition, the prompt outcry aspect, it is important here because nobody did anything the first couple of times that she told anybody what had happened. The first time, she told her friend, but her friend wasn't going to do anything about it. Then she told the staff. They sent someone to talk to her, but they didn't do anything about it. And the defendant stayed there, living in the same apartment on the same floor. Then the next day, she told her friend in more detail when she was outside for the first time. And then again, she told the staff when she came back to the building and the defendant was still there. So nothing really happened until the fourth time she told anybody what had happened. So that sort of explains why she had to keep telling people. In addition, I just wanted to add, as far as harmlessness, in this case, both sides used everything she said for their arguments. The defense made a lot of the fact that some of the things she said were inconsistent. In addition, the defense was able to cross-examine not only the complainant who said these things, but everyone she said them to. So the primary concerns about the hearsay would be that you wouldn't be able to cross-examine. And here, the defense could cross-examine everybody. In addition, because it was a bench trial, the judge was less likely to be swayed in the wrong direction by evidence that wasn't admissible. And so there was the least possibility of harm. And finally, because the defendant was on video outside of her room for 30 or 40 seconds before he got in, it put the lie to the notion that he just walked in consensually and had a consensual encounter. Clearly, he was at the door for a long time before she opened it and he pushed his way in. If there are no other questions, I'll ask the court to affirm.
Thank you.
Thank you.
Just a couple of other points on the hearsay argument. There's no authority that my adversary cites extending the prompt outcry exception to bench trials. I have found no authority. This would be an unprecedented expansion of that exception. The logic, again, only applies to jury trials. As for the excited utterance exception, as Your Honor pointed out, this, again, would be an entirely inappropriate exception to apply under the circumstances. There's no evidence of emotion when the text messages were sent. Beyond that, there's extensive time periods that pass subsequent to those statements and the three other statements that occurred. And I just want to make sure I address harmless error. The evidence in this case was not remotely overwhelming. The case was premised entirely on a single witness account. And even were the complainant credible, the many cases we cited in our reply at page 19 establish that a single witness case of this nature rarely meets that standard, especially where hearsay, as here, has a bolstering effect. The remaining evidence has to be, as the Second Department said last month in Crudup, also cited in our reply, unusually creditworthy. So the evidence wasn't overwhelming here, and the court need not look any further to reverse in this case. But even assuming that the court finds that the evidence was overwhelming in this case, given the extent the prosecution relied on the statements, from acknowledging their importance through litigating the admissibility of them extensively prior to trial, to using them extensively on their summation, there was a significant possibility of Mr. Gideon's acquittal without it. And I just want to address the point that this was a bench trial. The standard that the Court of Appeals has applied in Pabon and Smith repeatedly to examining a bench trial is not to presume that the judge didn't consider the evidence. It's instead to look to the record to see what the judge did consider, and here you have the court asking to review the hearsay statements. That, and along with the surveillance videotape, were all of the court asked for during its deliberations.
Thank you.
This evidence did have a harmful effect, and we'd ask the court to reverse.
Thank you.
Thank you.
Davis versus Davis.
May it please the court. May it please the court. Good afternoon, Your Honors. Alicia Talby of Yankwit LLP for plaintiffs appellants Carol and Bernard Davis. The trial court's February 28, 2020 decision should be reversed and the plaintiff's complaint reinstated on 3 primary grounds. First, the trial court dismissed the complaint on a ground that was not raised by the defendant in her motion to dismiss and was not argued by the parties, and plaintiffs were severely prejudiced as a result. Second, the court clarified in a later ruling that in issuing the decision, the court had converted the motion to dismiss to a motion for summary judgment, but adequate notice was not provided to the parties as contemplated by CPLR 3211C, and none of the exceptions to the notice requirement were applicable here. And finally, the complaint did assert a cognizable quiet title claim under APL Article 15 based on the plaintiff's equitable ownership interest in the brownstone at issue. The plaintiffs had asserted this quiet title claim against their son and soon-to-be ex-daughter-in-law after
So this was after about 10 years. They were in this, there was at least allegations that they had discussed this 10 years earlier, where the parents paid an amount of money and then began to live there, I guess when they were in New York. Seemed like they had another place also, but took occupancy there and were living there. Is that your basis for saying that there's a quiet title claim here?
Your Honor, that's part of it. There are several things. They're including a written contract between the legal title holder, Peter Davis, and
Is that contract in the record?
Yes, it's at it's page 123 of the record. So pursuant to the terms of that contract, Carol and Bernard Davis paid $350,000 to their son, which represented 25% of the purchase price of the brownstone.
Counsel, did it make any difference that the deed was not, the parents' names were not on the deed? Did that affect the legal analysis here at all?
So the fact that they're not on the deed is why we're here. We recognize that this transfer did not transfer legal title under the deed. We recognize that, and that's why the claim is asserted as an equitable one. And the law in New York supports a quiet title claim on the basis of an equitable ownership interest in circumstances just like this one, where they do have a written contract, they paid the purchase price, they took possession of 25% of the brownstone in the form of one of 4 of the apartments. They believe this apartment is theirs, and they purchased it. The fact that the deed was not transferred to them is why we've asserted a quiet title claim.
What is the strongest authority for that proposition that an equitable interest can support a repapple Article 15 proceeding?
Sure. So there are several cases that we've cited in our brief that recognize an equitable claim arising out of a contract and payment of the purchase price, including the Heritage case, the CARP. There is a persuasive, although not binding on this court, there is a persuasive interpretation of New York law by the Southern District of New York in Lip v. Genlight, which is cited in our papers as well. And it recognizes that a situation where title or the deed is not amended, but the contract exists and there's a payment, then equitable claim can arise.
Should we be concerned, or and maybe we are concerned, but is there a problem with the fact that your clients did not assert this claim until a few years into the going of the matrimonial action with which I believe it's been consolidated by stipulation?
Well, if you're referring to a statute of limitations issue.
Well, I'm not really talking about statute of limitations, but I mean, this seems like a pretty important claim on the part of your clients. Why did they wait a few years after the matrimonial was going to actually assert it?
Sure, and I think the truth is that the last thing they wanted to do is insert themselves in their son's divorce proceedings. Their understanding was that there was no issue as to their 25%. Their soon-to-be ex-daughter-in-law had recognized it in the past and it wasn't until they realized it was seriously being disputed in the divorce that they realized they needed to come forward to protect the interests.
Thank you.
Thank you.
Good afternoon, Your Honors. Stephen Sassoon, Rosenberg, Feldman, and Smith for respondent. During the pendency of respondent's divorce action with their son, they first heard about this purported 25% transfer in 2011 of this interest of their marital home. Peter Davis never added to the deed in these 10 years. He chose to take title individually. And then in response to this 10-year freeze-out, you could say, of their rights, they chose to wait until it only became an issue of equitable distribution in their soon-to-be ex-daughter-in-law. During those 8 years,
I mean, there is a contemporaneous contract, right? This just didn't show up out of nowhere. There's a contract dated several years earlier, signed between him and his parents, that reflected this transaction, right? It didn't come from whole cloth.
Correct.
So it's not really accurate to say, oh, the first time this came up was in the divorce. There was a contract.
Well, the first time respondent ever saw a copy of this contract was in the context of the divorce proceeding.
So was anybody else but the parents ever living in that first floor part of the brownstone?
No.
Did they ever rent it out to anybody?
No, they did not.
Did anybody else ever come and stay for 2 nights?
Not that I'm aware.
So the whole time that they were there, the couple, the parents were the only ones using that ground, I think it was the ground floor, right?
Correct, it was 4-floor
And then
brownstone.
there's a contract from the time around which the husband says that they agreed to the 25% interest, correct?
Correct.
And you're saying those 2 facts are not enough to at least state a claim for a cloud on the title?
Well, I'm saying that the fact that Mr. Davis, Peter Davis, the son, represented that he was the individual owner of this property for over 10 years to public agencies,
I agree,
state,
but I
federal
mean, it's
agencies,
his
that he should be
parents,
stopped
right?
at the least
Let me just,
from contradicting
right?
that.
I'm sorry, I don't mean to interrupt you. Go ahead.
Oh, go ahead.
It's not like it's a stranger he sold this to, it's his parents. And so it's not so surprising, is it, that he didn't do the formal resettling the deed. First of all, you'd have to pay money to do that. And secondly, it's his parents, it's not a stranger, correct?
That is correct.
I don't find that, do you find that so shocking or outrageous that he didn't change the deed?
Yes, because ultimately, it's almost as if they had an in-law suite, but in-laws who visit your marital residence aren't necessarily owners of that residence.
That's true, but as we pointed out, and you pointed out, in the record, there is a contract that was dated, some years ago. So, not everybody has that with their parents, a contract. And also, there was something I read in the record, that there was a discussion between your client and her parents and Mr. Davis, the husband, soon-to-be ex-husband, had discussed the possibility of them maybe wanting to be interested in doing that also, but they didn't take an opportunity. I think what, I might be thinking is that there's an awful lot of questions here, and I'm not saying she wins, goodbye, but should the case have been dismissed with all these questions looming?
Well, the lower court found that the pleadings were not sufficient to support an RPAPL, Article 15, specifically that there's no cloud on title. And what we can infer from that is he has an agreement to purchase a 25% interest in a single real estate asset, which you cannot do as a matter of law. This is not a condo. This is not a co-op. There's no joint venture agreement. There's no LLC agreement that owns the property as a whole, and that the appellants could buy a 25% interest of this property as a whole. You can't just simply buy the backyard of a property or...
Why not? If there's an agreement and both parties agree and they agree that they're going to own the building together, I mean, as my colleague has said, there's a question here. It's not decided, but why can't there be, given the facts that we know on this record, why couldn't someone conclude that?
Well, I think you can, but you need an agreement.
Well, there is this contract in the record.
There's the contract saying that he's to give them 25% of this property. It can't necessarily be partitioned pursuant to a purchase agreement, where it would need an LLC agreement or some other entity owning the property as a whole, and then you could sell interests pursuant to that.
Okay, thank you.
You're welcome.
Counsel, I want to go back to that. Do you agree with your adversary that you can't sell 25% of your interest in property?
I don't, Your Honor, and I will point out this is the first
You don't have to
that this
form an
argument is
LLC
being made
to do
in
that,
the
right?
motion papers, in the appeal. Right now is the first I've ever heard that argument, and I'm not aware of that being the case under the law. As Your Honor pointed out, the contract contemplated a 25% ownership interest, and that's what my clients purchased here. Just in response to the notion that Peter Davis has held himself out as the sole owner, the court did say that based on a very limited record that was pre-discovery and on a pre-answer motion to dismiss. Any representations that Peter Davis may or may not have made to third parties should not be held against my clients, who are the plaintiffs here. Peter is one of the defendants, and the notion of dismissing their complaint because of representations that he may or may not have made to third parties was improper here.
Thank you.
If the court has any other questions?
Thank you.
Okay, thank you.
Thank you both. McMillan versus Marengo. Sir? You can be seated.
Good afternoon, Your Honors.
Afternoon.
Harry Pacheski, representing the appellants Valerie McMillan and Roderick Francis. We have here a lease between friends where Jack Colbert, who was in ill health, asked the appellants to move into his two-family house, and as an inducement to them, because he believed that they would be taking care of him, which they did, he gave them an option to purchase the property. when Mr. Colbert died, his brother, his sole heir, immediately.
I hate to interrupt you, but Mr. Colbert didn't pass away, I believe, until 2019.
That's
correct. The lease went until 2014. And the question here really is, did the option to purchase survive after the completion of this lease? Because it was never, they never entered into another written lease. They continued a month-to-month tenancy, from my understanding, for a long time. But how did that keep the option to purchase alive?
Your Honor, the lease provided, and the lease is one document.
Yes, I have it.
Not a lot of documents, and the title of the lease is residential lease with option to purchase.
Right.
The option was a central part of the lease. The lease provided that if the appellant stayed on with the consent of the respondent, they would have a month-to-month tenancy, and that happened until Mr. Colbert died about 5 years later, and the lease would be subject to all the terms and conditions, the tenancy, all the terms and conditions of the lease.
But doesn't the lease say that, provide that the option may be exercised at any time prior to the end of the term of the lease? And the lease was only 2 years and it ended.
We
didn't
contend that the
renew.
term of the lease
Just let me
continued.
finish. They didn't renew the lease, they just continued month to month. I think you just said that, right?
Under the lease. Under the lease document, they continued month to month. And the court below relied on an opinion of the Court of Appeals in the case of Gulf Oil against Buram Realty. We contend that that case is inapplicable and that the court erroneously relied on it. That case was a lease between two sophisticated commercial parties. This lease was a lease between two lay people living under the same roof.
Counsel, but doesn't the lease specifically say that if the tenants stay on, that it creates a new tenancy?
Yes, it does.
Right.
But
So,
it's a new tenancy under the lease. And the Gulf Oil case, which the court said was controlling, had 22 extensions over a 19-year period, and the lease specifically provided that certain terms would be applicable to extensions, not the option to purchase, which was at a fixed price. This was a fair market value option, so nobody was getting stuck with an unrealistic price, and it would make no sense for the tenants to become their landlord's landlord. So that everybody, and the record backs this up, everybody regarded the option as in full force and effect. And as a matter of fact, right after Mr. Colbert died, his brother's power of attorney came to Mr. Francis and they started discussing the purchase of the property. They agreed on a price. There was a contract. The appellants got a mortgage commitment. They hired a lawyer, and they were ready to proceed, and the respondent just disappeared. Now, I'm not going to go into what happened later about the reign of terror.
Counsel, let me just ask you this. The power of attorney doesn't have any power once the person dies, right?
Your Honor, I didn't hear that.
The power of attorney doesn't, he's not the person's legal representative.
Well, it's a power of attorney of the owner of the property. On Mr. Colbert's death, his brother, by operation of law, became the owner of the property. They didn't need an administrator here.
No, I don't understand what you mean by that, because I'm trying to figure out who has the right to negotiate. He doesn't. There hasn't been there's no estate administration.
Well,
nothing is going on. He goes on his own. He wasn't at that point appointed an administrator, right? And later, another person was appointed an administrator.
Well, the two people negotiated on behalf of Mr. Colbert, Mr. Charles Colbert, his power of attorney and the manager of the property. And the manager of the property made certain allegations in his affidavit, and every affidavit after that was by an attorney. They never refuted the appellant's version of what happened, and the version of what happened that the appellants asserted is realistic. They had the right to buy the property, and that right never ended. They exercised it, and lo and behold, the other side disappeared and made a contract at fair market value with a third party, established the value at $700,000. We believe that the appellants are entitled to summary judgment entitling them to enforce their written option.
Thank you.
Thank you.
Yes, please, thank you. At the podium, please, with the microphone. It's okay.
Gerard J. White for the respondent, Christopher Marengo, administrator of the estate of Jack Colbert. What you heard here today was a misstatement. Counsel, no disrespect to him, he stood here and he told you there was a mortgage commitment. There was never a mortgage commitment. And if you look at the record, you'll see it's quite clear. There was no mortgage commitment. You can't have a mortgage commitment without having a contract. And there was no signed contract by both sides. There was no mortgage commitment. What there was a pre-approval letter, which is very easily obtained, and it's not even in the plaintiff's names. It's in Valerie McMillan's name and her daughter. And, you know, I mean, quite frankly, they haven't shown income. They haven't shown a signed agreement. They haven't shown an agreed upon price. I mean, it comes down to really being a due process issue. I mean, you're telling me my client has to sell the property to them, to whoever they want to assign as the buyer for whatever price they want.
Well, so that assumes that the option isn't good, right? If the option's good, the answer is yes, you do have to send it to them. So why don't you address why you don't think the option survived?
I'm sorry, Your Honor, I couldn't hear you.
I know, this is so hard. Okay, I'm saying to you that your argument assumes that the option didn't survive. Because if the option did survive, you don't have a choice. You have to give it to the...
No, what I'm saying is look at the contract, because the contract's quite clear. The contract says it's valid for 2 years, and the contract, if you look at the devil in the details, the contract says if you want the same terms...
You're talking about the lease. That's
the lease, yeah. So if you want the same terms, all you had to do was ask my client, and he'd give you another written lease with the same terms.
Renew, you're
Yeah,
saying,
renew.
renew the lease.
But it also says that if you don't ask for it, then you're subject to all, it doesn't say the same terms, it says you're subject to all the terms and conditions. So that is actually significant, because if I'm getting the same lease, everything's exactly the same. If I'm subject to something in the lease, namely a provision that says that, you know, your option's canceled if you don't exercise it, plus also, you know, they had to give 6 months written notice, they had to hire a real estate appraiser.
So, counsel, you're saying that even if the option did apply, they didn't plead and they didn't show that they complied with the conditions under the option.
Yes,
So either the option didn't apply, or if it did, they didn't comply with the conditions preceding to exercising.
I'm saying the option terminated, and they had an opportunity to comply with it, and they didn't. And then, you know, there may have been attempts to try and give them a second chance, and they didn't comply with that. And, you know...
But you're saying that had nothing to do with the lease or the option, it was just something that was offered?
Yeah, it was something that was offered, and, you know, they didn't agree on terms. And, you know, I mean...
There was never a signed contract. There was a proposed contract, correct?
Exactly. Yeah, it was never agreed to by both sides. And, you know, actually, if you look at the case, and you look at the summons and complaint, they were suing for specific performance for $750,000, and then they decided, you know what? We probably can get this property cheaper. Well, now they're asking for it for $700,000. And then what is it going to be? 6 months from now, it's going to be $600,000?
There's no indication of that.
It's just not fair to do to my client. I mean, I have been here on this case and working on this house. I've been in this court. You know, the house has been subject to a tax foreclosure lien. It's still being actively litigated. I believe they already have a judgment of foreclosure and sale, and they've been holding off on it. That the estate has no other money. You know, it's just the house is the only asset,
Thank you.
and they want to wrap it up.
Thank you.
Thank you, Your Honors.
This transaction would have closed a long time ago if the respondent had honored the option to purchase. The lease.
But I'm looking at page 37 of the record, which is the lease, the option to purchase section of the lease. And it says this option may be exercised at any time prior to the end of the term of the lease. Upon expiration of the option, the landlord will be released from all obligations to sell the premises to the tenant. I'm trying to figure out how this option extended past the end of the term of the lease in 2014 when you never entered into another lease. You just your clients just stayed on living there month to month.
It is our position that they didn't have to. This is not a fixed price option. This is an option at fair market value, and the parties negotiated a $700,000 fair market value, which is the exact same price.
But that didn't happen before the expiration of the lease. They didn't exercise that option before the expiration of the lease.
It makes no sense, Your Honor, to say that this option was only viable for 2 years. The lease was extended on all the same terms and conditions, not some of them.
Thank you.
And I'd like to read just one excerpt from
Okay, I'll give you 30 seconds to finish that
the
up.
Buran decision. Gulf Oil. This rule is well stated in an English case, Sherwood v. Tucker, where the question was the same as here. The court wrote, it is quite clear that a landlord may be prepared to give to his tenant an option to purchase at a fixed price for a limited period of time. Circumstance of value may enable both parties to fix a sum which will stand for a definite time. We don't have this here. Nobody is trying to steal this property. My clients are trying to enforce their rights that were given to them by Jack Colbert, and I think that the record indicates that the parties regarded that the option was in full force and effect, not only during the 2-year period of the lease, but as long as the tenants remained in the property and the landlord didn't throw them out. Thank you.
Thank you. Thank you both. People versus Raymond Godfrey.
Good afternoon, Your Honors.
Good afternoon.
Catherine Pecor of counsel in collaboration with the Office of the Appellate Defender on behalf of Raymond Godfrey. Your Honors, Mr. Godfrey's conviction on the assault and attempted assault counts were based on legally insufficient evidence and were against the weight of the evidence. Specifically focusing on the physical injury element of assault in the second degree, as even the trial court observed in this case, perhaps the most striking thing about the evidence was the lack thereof. The prosecution...
Well, we had a video here, right? We have a video, and the video shows him hitting the victim in the head and what appears to be a pistol, and the person has a gash in his head. It's bleeding. The store owner is giving him tissues. The police testify to that.
Yes, Justice Renwick, I'm glad you brought up the video because I think that's important here, and I think respondent's brief significantly oversells the extent of the injury in the video. That video has been submitted to this court, and I urge Your Honors to watch it because it really does show what unfolds here. One of the most interesting things is, although, yes, there is an alleged gun involved in this attack, the video is pretty high quality, and you can see the complainant, you can see his face, his forehead very clearly. At one point, he bends down very close to the camera. On his forehead, where there's supposedly this fresh, bleeding, vaguely big gash, you can't see anything on the video. You can't even see a scratch. You don't see blood. He's dabbing at it with a paper towel. There doesn't even look like there's any blood on the paper towel. And one of the things that he does is after this encounter, he puts his headphones back on, he purchases something at the bodega counter, and he pulls his cap down low over his forehead, which I think someone who is suffering substantial pain would not have been able to do that. Of note, complainant's other behavior really cuts against the idea that he was experiencing substantial pain. For one thing, he refused medical attention. He actually berated the store clerk for calling 911. He didn't get any kind of treatment, wouldn't give a statement to the police. He says, oh, it's nothing. He even, after the assailant kind of says, oops, I got the wrong guy, I'm sorry, I was looking for someone else, the complainant says to him, well, who are you looking for? I'll help you go get him. That's one of the things that you hear on the video. These are not the actions of someone who is experiencing pain or impairment, let alone substantial pain. Again, it takes about 10 officers to subdue the complainant and remove him from the bodega. This is not someone who is impaired in any way, frankly, based on the evidence. And again, I think one of the points that respondent stresses heavily is the idea that there is something inherent about a gun or a heavy object used as a bludgeoning instrument that inherently creates physical injury. The case law really doesn't support that, and we've cited a number of cases in our briefs. I won't reiterate them here, but I believe those are on pages 31 and 32 of our opening brief. These are actually pistol whipping cases. This issue has come up. And these are cases where people have been struck in the head or in the face with a gun or a blunt, heavy object like a baseball bat, in some cases experiencing deep lacerations, bruises, swelling, in some cases requiring medical attention, and in some cases experiencing impairment for weeks or days. And in all those cases, New York courts have found that those pistol whipping incidents did not create physical injury. So there's really no sort of per se rule. We have to look not just at what theoretically could have happened with this type of weapon, but what actually did happen. And in fact, there's a significant gap between the type of injury one might expect in this instance and what actually happened. But again, I urge the court to watch that surveillance video. It is very revealing. It does have the 911 call audio overlaid over top it, and I think it really tells the whole story.
In your remaining time, I'd like you to address the suppression issue.
Certainly. So Mr. Godfrey's statement to the detective was clearly made when he was in custody. That's not disputed. And this is a situation where, the warrant squad is raiding his home at 6 a.m. His wife is there, their young child is there. And the detective starts by saying, well, Mr. Godfrey asks what's going on. The detective says, well, specifically what I'm interested in, we're executing a search warrant, but what I'm looking for is a gun. And, I could go through the whole apartment, but I don't want to put your family through that. He doesn't expressly ask for the location of the gun, but that situation is very coercive. Courts have recognized it doesn't have to be an express question to be the kind of thing that creates pressures that take away the element of free choice as to whether to remain silent or incriminate oneself. Again, I think respondent really hangs their hat on this idea that there was no explicit threat or explicit question. And I don't think the case law bears that out. I think when you look at the totality of the circumstances, what is clearly being implied here is we can ransack your whole apartment, we can traumatize your family, but you can help us not do that by giving up the location of the gun. And under those circumstances, his statement was not freely given and should have been suppressed.
Did Detective Matos mention the defendant's family before or after the defendant said, whatever you're looking for, it's not there, or words to that effect?
Sure. So it's a little bit muddled, but Matos' testimony is basically, first, he says he has a warrant and he can go through the whole apartment, but the only thing that concerns him is a gun or a firearm. Mr. Godfrey then says, whatever you are looking for is not there, it is gone. And then Detective Matos he says, I told him again, I know your family is there, I don't want them to go through me going through the apartment. And then Mr. Godfrey says, what Matos is looking for is not there anymore. So the very specific, I see my time is almost up. May I just say one more thing?
Yes.
So the very specific incriminating statement, what you are looking for, the gun is not there, was made after Matos mentioned his family. But also Matos says, again, I said to him, implying that throughout the conversation, Matos was making references to the fact that his family was there and that he could sort of do more damage on the apartment if Mr. Godfrey didn't confess.
Thank you.
Thank you.
Good afternoon. May it please the court. Jennifer Westfall for the people. Just starting from the suppression point, the hearing court properly determined that defendant's statements to Matos were not the product of interrogation. Defendant posed a question. Matos answered that question with a
Counsel,
fact.
Officer Matos, was he the one that put the defendant in handcuffs and took him to the police vehicle?
No, he wasn't.
He was not. And his purpose in going to the defendant was to have a conversation, wasn't it?
Yes.
And that's what happened.
Yes.
So the fact that he didn't ask a specific question and the defendant started the conversation, why does that matter? Matos got what he wanted, which was to speak to the defendant.
But he didn't pose any questions to defendant. If anything,
Well, the
defendant
case law doesn't say that you have to.
No,
does
but
it?
defendant used that opportunity to ask a question.
But why did he go there? Why did he? I mean, this is a case where they had a search warrant. They went upstairs. They identified everybody in the apartment. They then separated the defendant. They brought the defendant down 7 flights. They handcuffed him first, brought him down the 7 flights, put him in the van. All of this time, by the way, not saying why he was arrested or reading his Miranda rights. Then he gets to the van, and then the person who brings him there doesn't question him, but then the other person comes into the van, Matos. What was the purpose of all of that time that was spent with the defendant in handcuffs, bringing him down, never once saying what you're arrested for or reading him Miranda rights, and then putting him in the van? What was the purpose of Matos going in the van? And what would have been expected to happen other than the person saying, what's going on?
To be honest, Your Honor, Matos was never asked that question. He never offered an explanation for why he went down, or even...
Well, I'm asking you, based on what I just said, based on all the circumstances, there was no purpose to go in that van other than say, you're arrested for, and let me read you your Miranda rights. Anything else was for the purposes of interrogation. He wasn't going there to keep him company.
I mean, there's any number of reasons. He could have gone to relieve the warrants detective that was going to actually be doing the search warrant. Anything I say is conjecture, but Matos testified that he did not come and ask any questions. He didn't, unless his presence by itself is just interrogation, that I can't...
Well, what is the natural answer to what's going on where you've been arrested and you haven't been told what you've been arrested for and you haven't been read any rights and you're handcuffed and you're sat in a van? I mean, I don't even know how much time it was in between them entering the apartment and getting him down to the van. Had to be at least 10 minutes. In all of that time, nothing is said. So what would the natural response be to what's going on?
I think the natural response is what Matos gave. We have a search warrant for your apartment.
The natural response to what's going on is not you're arrested because we saw you hit somebody with a gun and now we're here to look for the gun. That's secondary. The fact that the man is arrested for something and he's not told, is that secondary?
I think it's part of the answer, but also the answer is we're going through your apartment with a search warrant and we're looking for a firearm. I think that's related to why he was arrested. The crime was with a firearm. I think it's part of a natural answer.
But
And
was
so
it
then,
that?
Go ahead. No, go ahead.
But was it that innocuous? Didn't Detective Matos bring up the defendant's family?
He only brought up...
Basically, I could spare your family.
I think it's important to know that the defendant made that statement twice, and the family was only brought up the second time. I mean, if you stretch Matos' testimony and read into it, yeah, you can assume that maybe he did say something about the family first. But in his testimony, he said, we have a search warrant, we're looking for a gun. And the second time he said, I know your family's up there, let's spare them. Even if that second statement is interrogation, it's a repeat of the first one.
Is that it?
Just, I want to say the people proved defendant's guilt on beyond a reasonable doubt on both charges. Though Hudson did not testify, there's no particular threshold of pain or injury. And the jurors were certainly permitted to use their common sense given the evidence that was presented.
What does the video show with regards to injury?
So I don't think the victim gets that close to the camera. So it's not surprising to me that you can't see a half-inch laceration on his head. It shows him being hit over the head with something that appears to be a firearm, and both the bodega employee and Hudgens himself confirmed that it's a gun in the 911 call. The video shows Hudgens repeatedly all the way through when the cops arrived, dabbing at his forehead, wiping at his forehead. And even after he's arrested, there's a police officer that was handling him that has to come and wipe his hands. But you can't see anything on his hands. The camera is too far away to see that specific of an injury. If there are no other questions, I respectfully ask that you affirm. Thank you.
Thank you.
First on the suppression point, Your Honor, so I think you've raised some important questions about why Matos made these statements to Mr. Godfrey. When Mr. Godfrey asked what's going on, I think you're right, Justice Renwick, that the natural response to that would be something like, you're under arrest for whatever the charge is, and then...
But there may be more than one, there may be more than one response to that. That might be
Exactly.
my opinion, but it could also be the question that was the statement that was made by Matos, or question. I mean, I don't know that it's that clear.
No,
that it's
maybe
a
not.
statement.
But I think if he had merely said, we have a search warrant, we're looking for a gun, that's one thing, but he really does take it further beyond sort of a direct answer to Mr. Godfrey's question by saying, hey, I could go through your whole apartment, but what I'm really interested in as a gun, I think we can all read between the lines as to what he's trying to communicate here. And of note, I think one case on point is the Perry case decided in 2012 by this court, where police executed a search warrant of the defendant's home and detained him, and actually, well, in this case, they did ask him to disclose the location of a weapon, so that is a distinction. However, essentially, they asked him to do so they wouldn't have to tear up his apartment looking for it. The case law, however, doesn't make a distinction between directly asking someone something and putting that person in a coercive situation where they may feel inclined to incriminate themselves. And just briefly to touch back on the sufficiency and weight of the evidence point, you know, if the complainant had this really bad bleeding gash on his head, then why didn't the police take a photo of that when he was in custody? They had him at the precinct. There could have been some documentation. You know, at some point, he's in handcuffs and he's at the precinct. At no point do they even take a photograph of his head. So we're relying instead on the surveillance video. And again, I defer to this court. View the surveillance video. You can decide how high quality you think it is, but there's simply not a scratch visible and not a drop of blood.
Thank you. Thank you both. Star indemnity versus U.S. adjustment.
Good afternoon, Your Honors. May it please the court, my name is Michael Huttenlocker from McDermott, Will & Emery. I'm appearing on behalf of the appellants Star Indemnity and Liability and Star Surplus Lines Insurance Company. In the action below, the Supreme Court erred when it failed to grant Star summary judgment on its breach of contract claim and when it dismissed Star's professional negligence claim. First, with respect to the breach of contract claim, the court below, as an initial matter, construed the contract and determined that at a minimum, the 2012 CSA's claim services agreements that were at issue required the respondent, USAC, to pay ALAE, which were the program expenses, in an amount up to the service fee. The proof before this court and before the court below demonstrated that USAC had hired a forensic accountant to determine how much money had been received from the service fee and how much was paid in expenses. The accountant determined that there was a delta of about $5.5 million that was not paid out in expenses. Those funds should have been paid to cover ALAE. When USAC came to Star and said, we don't have any funds in order to pay these litigation expenses, a fact that they withheld from Star for approximately 16 months, Star then stepped in and started paying the ALAE on its behalf. This is what USAC was responsible for under the terms of that particular contract. In the papers below, USAC admitted...
So wait a second, counsel. You submitted a summary chart, right? A summary chart on your summary judgment motion, correct?
With the
So this expert, that didn't show up till reply, correct?
No, that's incorrect, Your Honor.
Wait a second.
The accountant from USAC, that was with the original papers. The issue with respect to the amount of damages was the excess over
right.
the $5.5 million.
I'm sorry, I misspoke. So you're talking, so the question was whether or not they had to pay more over that amount, correct?
Correct.
And you're saying as a matter of law, they did.
Yes, I am.
And the trial court said that's an issue of fact.
The trial court did not address the supplemental response that was put in that had the verified responses on the interrogatories.
Because you put it in too late. So in the first instance, the trial court said that's an issue of fact because the contract is ambiguous, correct?
I'm not sure that I read the opinion the same way, Your Honor.
Well, tell me how you, what do you think? Because I'm
Yep.
looking, I think what he said was, it's not, it doesn't ambiguously require that.
Yeah, and the court at the record, it
So that means he found it to be ambiguous, correct?
So the court said at a minimum,
right,
that it can be construed to say that it was up to the amount of the service fee. Now, if the court finding that minimum is entitled to make a ruling on partial summary judgment, which is what Starr requested, that is an amount that would be due and owing to Starr as a result of the breach, as that was not paid in
But that
expenses.
wasn't your argument, correct? Your argument was that I owed more than that.
We're arguing in the alternative, right? If the court does not find that we're owed the entire amount, that there's some ambiguity in the contract, the court did find that at a minimum. Now, with respect to the...
So, and with respect to those damages, that's when you put in the summary report, correct?
There was a summary chart that was attached, and the
And
interrogatory itself said...
all that you are arguing about now came in on reply. All that you are discussing now came in on reply, correct?
Not the account report, that came in earlier.
Right.
But the verified interrogatory and the backup that went with it, I do say that did come in on reply.
And so the judge said that what you put in initially was insufficient to make a ruling as a matter of law, correct?
Yes, but
So
did not...
presumably, you could go to trial and put in everything that you didn't put in the first time to make up the deficiency.
If that was what the determination was to go to trial, yes, that could occur.
Well, isn't that what the determination is?
Well,
go to trial?
Though Your Honor didn't address the court below did not address the supplemental filing with those additional papers, nor did he rule.
Let me just, I'm sorry, I didn't mean to interrupt you.
I'm sorry.
I just want to say, isn't it a fact, if you get denied summary judgment, you go to trial, right?
Yes.
So you can, whatever you forgot to put in or didn't put in that was not sufficient, you can put that in at trial.
Certainly, but the record here that is on that particular point shouldn't require a trial in order to go forward. The documents that were provided with on the reply it's not a new piece of evidence that was coming in or that was something that was surprising to the other side. The verified interrogatories that were submitted earlier in discovery were verified and provided to the other side that showed at the time there was an overpayment of $21 million. It was the time of supplementation where that number had raised up to $58 million where that was put in. But setting those, and if you look at not only the statement that's in the interrogatory that's verified by folks who are employees of STAR who have managerial responsibility over the particular claims program, they're the ones who said in their interrogatory, in making the statement and verifying it, they made this payment. And then the backup is clearly, in our view, a business record that should be seen and viewed by the court as a way to supplement those damages.
I just want to clarify this one point because I may be mistaken, but originally you put in an unverified document.
Yes, that is correct, Your Honor.
So an unverified document on a summary judgment motion isn't in evidentiary form. We both agree with that. I mean, that's pretty straightforward. Unverified is, and you didn't put in an affidavit from that person, correct?
We did not put in an affidavit from that person.
Good. Then we're on the same page. Okay, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. My name is Richard Ash, and I just dropped all my papers.
It's okay.
I think in part, Your Honor, hit on one of the problems with their contract claim, and that is that there was absolutely no effort to prove damages by use of any admissible evidence during the initial submission. Even in the reply, when they put in that big computer printout, there was no affidavit from anyone with personal knowledge as to what that was, how it came about, whether it was prepared for litigation, whether it was a business record or anything. So even
Counsel, what is your position as to how much you had to pay? Did you only
here's
have
our
to
position.
pay up?
As to there are two sort of alternative claims. One is that our client owes $58 million because that's how much they spent after they terminated the agreement. The answer to that is that there's a provision in the contract that says that we're to pay this ALAE, which are basically legal expenses, from the fees we receive from Star. And it's undisputed that the fees were $21 million, more or less, $20 to $21 million.
So wait, so
What
it's
Star
your
says,
position that it was a cap?
I'm sorry?
It's your position that it was a cap? That phrase?
It was capped, yes.
And it's their position that it's not?
It was their position that you skip over that provision in the contract and ignore it, basically. The second, their fallback position, is that even if we don't owe $58 million, we owe $5 million plus because that's how much of the fees we got we had not paid at the time that they terminated the contract. However, it is undisputed in the record that it was Zimmer's position that that money was owed by Star. There's no evidence that it wasn't owed by Star, and Star received the benefit of the services connected with that money. So Star has not out of pocket one nickel with respect to those outstanding fees, and Star terminated the contract, leaving USAC still responsible for the $5+ million in fees, and wrote us and said, we're not responsible for those fees. So it's hard to understand how Star can show any contract damages if they didn't pay any of that money. In their reply to this court, Star seemed to indicate that we had made some kind of admission that they had paid attorney's fees after they terminated the contract. There's no question that they paid attorney's fees after they terminated the contract, because otherwise the attorneys wouldn't have kept working. But there is no suggestion anywhere in the record, not even an affidavit by anyone connected with Star, that the $5 million that USAC owed upon termination of the contract was ever paid by Star. So what we're saying is that that as a matter of contract interpretation, as an absolute minimum, we're entitled to a trial as to whether the contract means what it says. We think probably we're entitled to a directed verdict, but we didn't make a motion, so we're not pressing that. But as a minimum, there's a question of fact. As to the $5 million, there's just simply no evidence that Star was in any way damaged by our alleged default in paying these attorneys, and that obligation continued after Star terminated the contract. So in essence, we'd be liable twice if Star were correct. Now, there's another aspect to the appeal that Mr. Huttenlocker didn't get into, and with him, I'm prepared to submit on the papers on the negligence issue, unless the court has any questions about it.
Thank you.
Thank you.
Your Honors, if I may, with respect to a couple of the points that were made by a respondent, on the question as to whether the full amount of the all ALAE that is paid on this particular program is owed by the respondent, it's not just to skip over that particular contract, the particular provision with the from the service fee language that the respondent points to frequently. When you look at the contract in its totality, there's a clear division between who is responsible for paying indemnity and who is paying on the expenses. STAR takes on the indemnity and USAC takes on the ALAE. That's found both in Section 3B of the contract, which is 361 and 392 of the record, as well as Schedule 2, which states that the fee will include all of the ALAE. There is a clear division as to who is paying what under these contracts, and it was to incentivize USAC to make sure that they had skin in the game to control the expenses of this particular program, and that they would collect profit above what would be paid out otherwise in expenses. With respect to
if the intention of the parties was the defendant be fully and wholly responsible for the ALAE, why not just say that? Why is it tethered to the service, the defendant's receipt of the service fee? Wouldn't the plain and unambiguous way of saying defendant is wholly and exclusively responsible for these expenses be to say that, period, and not have that coupling of the receipt of the defendant's receipt of the service fee?
Well, that could certainly be an alternative way to say it, Your Honor, but that's not the only way that one can say it. And it's our view when looking at this contract in its entirety and in its structure, and frankly, because the court found the ambiguity below, had the extrinsic evidence, which was the email that followed from Richard Alexander, which is at the record of 353, which after the negotiations were concluded says, this is your payment and you're covering the ALAE, and when that says all legal, that they're covering as a result of this contract.
Thank you.
Thank you, Your Honors.
Thank you both. Shihada versus those awesome guys.
There's a lawsuit against Julio and I today?
I include myself.
No, you just don't want those papers.
Those awesome guys.
Awesome guys.
Good afternoon, Your Honors. May it please the court. Michael Zhu on behalf of the defendant, those awesome guys. I've been waiting to say that for a couple of weeks.
Yeah, so was I.
The trial court erred in denying the defendant's motion for summary judgment and dismissal of the breach of contract claim, finding that there's a question of fact as to adequate consideration and whether the contract itself was ambiguous. The plaintiff himself admits at his deposition when he was asked whether he understood that last line in the assignment agreement and what he understood that to be. And he testified that he did understand what that last line meant. And I'll quote, this is at page 137 of the record, it's really short. My personal understanding is that this means I'm allowed to put it up the fact that I made the game on my website and resume. Did you believe that your ability to do that has value? Yes. The concession there that the assignment that conferred a right to him to promote and market the game as if he coded it himself, which he didn't because he stopped midway, is consideration.
Well, let me ask you, the term for good and valuable consideration that's in the contract, is that defined in any way? Is it modifies?
Yes.
Does it modify anything in there?
It is defined. It's defined in paragraph 1, where the assignment grant is provided.
And part of that is supposed to be able to go to college, I believe. Does it say anything about it meaning that he can go to college?
I'm sorry, that it included?
Part of that is that he was supposed to be able to go to college. Does it say anything there about his being able to go to college in the contract?
No, it doesn't.
Part of the consideration.
No.
And yet, that's a major part of the consideration, it seems that you're saying.
Yes, it is. That he was allowed to do, but look, he wanted to stop working on the game so that he can go to college. And so the parties had never come up with this situation before where he wanted to stop the work. So they had to create an agreement to transfer the rights. And in doing that, he was given the right to do various things. Unwritten in here was his ability to continue to go to college. But what else is contained in here is the marketing and taking credit for work that someone else had done. And that's a...
Are you saying he did no work on that project?
No, obviously he did do work, and he admitted this in his deposition that there were various aspects of the coding where he was unfamiliar. So including the online network portion of the software. So they hired a guy to come in because he couldn't continue doing it anymore. So Martin came in and he performed the coding work, and he rewrote the code that
So,
plaintiff
counsel,
originally
let me
worked on.
just interrupt you for a second and ask you, didn't the plaintiff put in an affidavit from an expert who said that all of the plaintiff's coding, all the plaintiff's work was still in the version that was being sold and apparently created $11 million or some $1 million of revenue?
Sure, but...
So your statement that this, the guy left it, the plaintiff left this in its infancy, ran away, and then somebody else, that factual statement is disputed by an expert submitted by the plaintiff, correct?
Sure.
Okay, so already that's a factual statement. Second, when you say it says for good and valuable consideration, what did he hand over for the good and valuable consideration?
What did who hand over? I'm sorry.
The plaintiff. The plaintiff says for good and valuable consideration, I'm going to give this to the company. And what do you think this is?
The intellectual property rights to the game.
To the game, correct?
Absolutely.
And there's no doubt that he worked on the game, and so he could, without your permission, say, I worked on this game. That's a true statement. He didn't need to be paid for that because that was a true statement, correct?
Correct.
So your statement that the good and valuable consideration that he got was something that he already had the right to do.
But a court in evaluating and assessing whether consideration is valid or reasonable does not get involved in subjective beliefs. Look, I can come in today and sell you a block of ice, and we're in Alaska. And if you're willing to buy that block of ice from me, then that's valuable consideration. That's
yes,
given.
And if you put in, I'm buying this block of ice for this, then that's one thing. There's nothing in that particular section that talks about what he's getting. It's only in a later section, and you're trying to connect the two, and that's a clear ambiguity. Wouldn't you agree? Obviously you don't.
No.
But because of the fact that what you claim he was getting was something he already had.
But you have to look at the four corners of the agreement. So even though that language in that last sentence in the assignment clause is not in the preamble, doesn't make it not so.
Well, counsel, to use your analogy, in this case, isn't your client trying to give the petitioner the block of ice that he already owns?
No, because he was able to do it.
He has an interest, but doesn't he have an interest in that block of ice?
I'm sorry, doesn't he get?
He has an interest in the game.
Not when he leaves.
He already had an interest in the game when they... My question is, didn't he have an interest in the game at the time that they were negotiating this contract?
Yes, they did.
Okay.
But this is to negotiate him leaving. So this isn't, hey, let's work together on this, and then you'll get this and I get that. This is, hey, I don't want to do this anymore. I'm leaving.
Right, so the consideration that's being given to him is something that he's already entitled to.
Yeah, but he
arguably.
Well, no, I mean, if he had left and stopped working on this game, he could not go to prospective employers and say, hey, that's my game, I wrote it.
No, but he could say, I worked on it.
I worked on it, sure. But he marketed himself as I was the creator of that game. And the game that was ultimately commercially put out is not what he wrote. So the idea that he got nothing out of this is incorrect. I believe that there was value consideration that was exchanged, because he himself agreed that there was value to doing that. He got interviews, he got jobs, he got internships, and he got paid for being able to put that on a resume.
Thank you.
Thank you.
Good afternoon. May it please the court. I'm Robert Greener from the Law Office of Robert L. Greener on behalf of the plaintiff respondent in this matter. And just before we begin, Your Honors, I have a little hard hearing in my right ear, so if you can please just speak up when you ask your questions so I can answer them properly. Thank you. I want to start
What
with...
consideration do we get for that?
My good wishes. I just wanted to start off with a point that counsel goes immediately into the deposition testimony, which is intrinsic evidence. And in order to do that, he has to admit there's some kind of ambiguity for this court then to review that testimony. And if it does, what the court will see is clearly there were never any discussions or negotiations about the alleged consideration to either attend college or for the license. And
So let me just ask you this. Was your client represented by a lawyer when he signed the agreement?
no, Your Honor. He was a teenager and he was residing in Egypt.
A non-U.S. teenager. He signs this agreement without a lawyer.
Absolutely, Your
Who
Honor.
drafted the agreement? Do you know?
Can you repeat that, please?
Who drafted the agreement? Do you know?
The defendant, Mr. Burbisi, hired a New York intellectual property attorney to draft that agreement, who we would have to assume was sophisticated in the topic and would have known to include a lot of these provisions. And as I say in my brief, I believe that they were intentionally left out because it would have called to attention to Mr. Shihata that he wasn't going to receive his share of the commissions, which he believed he was going to as part of the discussions and the course of conduct between these parties for 6 years. So that's why I believe it's not in there. But really,
When he signed his intellectual property rights, did he sign it just to the corporation or to the corporation and to the individual defendant?
well, what the corporation told my client, actually what Mr. Burbisi said is that my client is not a member of the corporation, but that was never clear. All we know is that it was filed in Romania and that Mr. Burbisi never actually showed my client any of the in filing of corporation documents. But if you look at the chat log, what is made clear is that the defendant, Mr. Burbisi, told my client that in order for them to get paid from the Steam platform where it was going to be launched, he needed to have the corporation receive the money on both of their behalves because they wouldn't split the profits. So he clearly articulates in that deposition, in that chat log, that he would receive those profits, split them, and then give them over to Mr. Shihata. And he even describes the method to do that. He said, set up a corporation, submit invoices to those awesome guys who aren't so awesome, and then we will pay you like we do Martin Vandermeer. So he relied on that as an indication that he was going to be paid, and he said that he would do it as soon as he could, and so that he would hire somebody and they would set that up. So that was his understanding, and it was in the contemporaneous statements of the parties, which has been acknowledged and authenticated by the defendant.
Counsel, how old was your client when he signed that agreement?
I'm sorry?
How old was your client when
I
he
believe
signed?
he was 18.
18?
Yes.
Unrepresented 18-year-old?
One more time, Your Honor?
Unrepresented 18-year-old?
An unrepresented 18-year-old, yes, based upon a 6-year relationship between these parties. And also, I just want to address the question of the ambiguity in this contract. The defendant's entire argument and appeal depends upon this court finding the lack of ambiguity in this contract. And I want to point out that one of the main arguments, not advanced here in oral argument, is that there was a waiver or forbearance of royalties in return for this so-called license, okay? Nowhere is in the four corners of this document are the words waiver, royalty, forbearance, college, or coding. Doesn't appear anywhere. The agreement is completely silent. Also, other than the preamble, which uses the general boilerplate, the grant of rights doesn't contain the words consideration or any other mutual language of covenant that would indicate that these parties intended to exchange something, even if it's an implied forbearance to do something. According to this court in the Milagros, I think, I'll give you the exact site in a second, said that there has to be specific language of specific intent to waive or forego something, and that does not appear anywhere within the documents itself. So even on the four corners of this, it's clear this document, and on just following counsel's own argument, it's clear that the document itself is ambiguous, that it doesn't contain the necessary words or mutual covenants that would support his claim that this was a so-called consideration. And in fact, just one more point, right at the very beginning of the assignment, and the assignment can be found in the record on 94, right in that very first section on the assignment grant, it says, the assigner does hereby sell, assign, transfer, and set over the assignee all of his right, title, and interest. Assigner being Mr. Shihata, and the word sell is there. And using the rules of interpretation, the court must give that word its legal meaning, and sell is clearly meaning to transfer something for some kind of monetary value. Thank you.
Thank you.
Just very briefly on the issue of ambiguity, and whether
Counsel, let me just ask you, do you dispute, you don't dispute, I should say, or do you dispute that when he signed the agreement, the plaintiff was an unrepresented 18-year-old?
Yes.
Okay.
And the defendant was a teenager as well.
But he had an attorney, correct? Because
Yes.
I'm sure your client didn't draft that agreement.
I
I
think
have
at
no
the time
personal
of
knowledge of that.
drafting,
They're very good at games, you know, these intellectual, I mean, these games, but not so great at, you know, they weren't lawyers.
Yeah, but what's not to be forgotten is even though the plaintiff was a teenager, there's no argument here that he couldn't read or understand English. There's no argument here that he couldn't.
but he had no attorney. The other gentleman was 2 years older and had an attorney.
I agree. But he certainly would understand after reading this agreement, seeing it, that
And there was
the words
an element
royalty-
of trust there after 6 years. I guess there was an element of trust.
Sure.
After
But
6 years
the
of working
words,
together.
but the words royalties, profits, split, 50-50, they don't appear anywhere in there. So if I'm a teenager and I'm reading
But
this as a word,
college doesn't appear in there either, and you said earlier that was a big part of this whole thing.
Your Judge, I understand. But if I'm a teenager reading this for this first time, and I'm thinking in my head that we're splitting profits on this, and I don't see it in there, my first response is, hey, Nicholas, what's going on here? How come it's not in there? Say
Or
something.
maybe if we credit the plaintiff's version, Nicholas, I think is the defendant, says, look, we got to do it this way so we can get paid. And he doesn't, and he trusts that that's true.
But that's not what he testified to. That's not what the plaintiff testified. The plaintiff didn't say, Nicholas told me that we had to do this, that, or the other so that we can get paid. What the plaintiff testified to was, I read it, I skimmed it, I didn't understand it. He didn't consult family, he didn't consult friends, and he didn't consult an attorney.
Thank you.
So on that basis alone, if the ambiguity is created out of a unilateral mistake by a party, that's certainly insufficient to find ambiguity within a contract.
Thank you. Thank you both. Herbie Forensic Psychiatric versus Sammy M.
May it please the court, Mark Rube for Kirby Forensic Psychiatric Center. While suffering from active psychotic symptoms, including hearing voices telling him to commit violent acts and delusional beliefs that his wife was having an affair with the imam of his mosque, Sammy M. committed an unprovoked attack of extreme violence, striking the imam in the head with a hammer while he was
So we know the facts here, so why don't you get to the question that we're looking at as to whether or not we should release Sammy to a less secure facility than Kirby?
Sure. So the same active symptoms that I was just speaking about, hearing voices in his head, he continues to exhibit, and he admitted this at the hearing while not recognizing that hearing voices in his head was an active psychotic symptom. So he demonstrated, and this is what the Court of Appeals has said in George L., and this court has said in Joseph C. Courts look to whether there has been sufficient therapeutic progress since the underlying crime to justify transfer to a civil facility. And here, that has not happened because Sammy M., as I said, does not recognize his symptoms. And further, he has not developed the tools, a relapse prevention plan. He hasn't been able to identify early signs of decompensation.
At the hearing, I know you want to get that in, but at the hearing, he does say, he indicated that his belief that his wife was cheating on him was a symptom of mental illness. So he didn't simply, it's not that he didn't recognize that to some degree, is it?
Well, in the testimony, for instance, in the interview with Dr. Lamb, it said he vacillates between recognizing the delusions about his wife and not. So we agree that there has been some progress, and there will be opportunities for him to seek transfer again in the future. And if this progress continues, OMH can also transfer him on its own initiative. But as the psychiatric record stands right now, in the hearing, he said, I hear God's voice, I hear a friend's voice, everybody knows God's voice. And so,
But I mean, a lot of people hear God's voice who have mental illness and who are in a facility. They're not in Kirby, they're not in the most restrictive because they hear God's voice.
Well, but for this one,
you would agree that alone wouldn't allow you to meet your burden of a preponderance of the evidence because he hears God's voice.
That's correct. What's here is the George L. presumption that in the past, these voices in his head have caused him to commit an act of violence. He hasn't been able to develop the tools to deal with that, to recognize signs of decompensation, and to seek treatment and help. And that he needs.
Weren't you required as part of your burden of proof at this hearing to show that the respondent continues to exhibit a level of dangerousness that warrants his continued retention in a secure facility?
That's correct. And the dangerousness is established, first of all, as I said, by George L., by the violent conduct and the continuing symptoms. But I also would like to emphasize that the lack of insight, as I talked about before, there was testimony that sometimes he recognizes his symptoms, sometimes he doesn't. He hasn't been able to link his symptoms to his act of violence. He just sort of can simplistically recognize that he has a mental illness, but not explain how the symptoms have led to violence in the past.
Thank you.
Thank you.
Good afternoon. May it please the court. Sarah Diane on behalf of the Kings County District Attorney Eric Gonzalez. We agree with the Attorney General that no fair interpretation of the evidence supports the Supreme Court's decision to transfer. I'd just like to emphasize a few points, specifically about this defendant's ongoing active psychiatric symptoms, but moreover the fact he doesn't recognize them. It's the minimal insight that we see here, not only from the testimony of the doctor, but from the defendant's own testimony at the hearing, shows that he does not understand his own mental illness and that the voices that he is hearing, namely the voices of God, the voices of his friends,
are actually hallucinations. And also it's worth noting, these are command auditory hallucinations, similar to command auditory hallucinations that he suffered back in 2008 when he hit the imam in the skull with a hammer. It's also worth noting, just to touch upon the differences of a secure and a non-secure facility. They're both physical differences and treatment goal differences. Physical differences include there's a higher staff to patient ratio at a secure facility. Visually, a secure facility is surrounded by barbed wire. The patients have less freedoms. In a non-secure facility, there is no barbed wire on the outside. There's no guard sitting at the gate to prevent people from leaving the grounds. And a treatment goal-wise, there's very specific differences between secure and non-secure facilities as well. In a secure facility, the treatment goal is to treat a dangerous mental disorder, which the defendant still has. In a non-secure facility, it is to it's to reintegrate this defendant into the community, which he is not yet ready for because he has not sufficiently mitigated his dangerousness.
To what extent are we required to give deference to the trial court, hearing courts, credibility determinations and factual findings, particularly with respect to the credibility of the respondent?
I think it's very important to note that this medical testimony was uncontroverted and unrebutted. There was no medical expert testimony given by the defendant. It's also important to note that this court has fact-finding jurisdiction and the Supreme Court simply got it wrong. He credited factors that were not credited by medical experts.
Thank you. Any
Thank you.
questions? Thank you.
May it please the court, I'm Diane Tempkin for respondent Sammy M. First of all, I'd just like to say there was no evidence that there was no barbed wire on a non-secure. In fact, in Kirby, in the same building, there's a non-secure facility that has the same entrance and the same security perimeters, but that was not part of the record about.
Is that Kirby where he's being considered for transfer?
Well,
that hasn't been determined.
It hasn't been determined which facility, but he has no history. He's been in non-secure facilities before. There's no history of him eloping or anything like that.
When was he in the non-secure facility before?
Before
the occasion of this
offense, before the 2008 offense on the imam, and also the evidence was rebutted. It was rebutted by the medical records. Appellants do not mention the medical records very much, but the medical record said that he was appropriate behavior with staff and peers, good behavior, no aggressive behavior, no violent behavior, no abusive behavior, no argumentative behavior, follow staff instructions. In fact, there were so many references in the record at trial, our counsel was cut off from even referencing them all because they said, okay, we got it already.
Well, counsel, under George L., aren't we supposed to give a modest or minimal amount of weight to good behavior in a secure facility, given the level of supervision, the level of restraint, the supervision of the taking of the medication? So the behavioral aspect can certainly militate in your favor, but under George L., isn't that supposed to be a modest factor in the equation?
Well, under George L., it's a higher level of dangerousness. There's two levels of dangerousness. So he still has to be dangerous in order to go to the non-secure, okay? But in George L., the dangers has to be based on more than expert speculation. It has to be, it can meet his burden by showing that there's a history of prior relapses into violent behavior, and or that he won't take his medicine, or he doesn't think he has a mental illness. Or in George L's case, it was 17 months before, after he tried to kill his father for the second time. And so even though he was compliant in the facility, they thought that he might not be compliant again when he got out. He might try to kill his father again. And also, it was a track hearing. It was an initial hearing, and they wanted to make sure that he was track one so that there would be continued court oversight, and the DA would always be involved. In this case, Sammy M's been track one since 2011, so there's no concern about that. And also, you have 10 years. You have 10 years of compliance with medication. It's been a long time already. And when the
But what about,
yes?
well, maybe you've addressed this, but what about the hallucinations? I mean, the compliance and the medication, okay.
Well,
what about his thinking? How has he advanced to that extent?
Right. Well, the records show that he speaks, the medical records show that he speaks about this delusion with the imam and his wife, and he's denied that he still has it. It says it in the medical records. Not only did he deny it at trial, but the medical records support what he says about it. And Dr. Lamb also testified that this is an improvement over his prior evaluations, and he can now talk about the offense and that he was under the influence of mental illness symptoms, and that he shows remorse. That's on page 54 and 55.
He's definitely, there's definitely an improvement, but it's the consistency of it that the question is whether or not he's improved enough to go to a less secure facility, right? So
Well,
what about?
it's still a locked ward, and he also would go with a transfer order and an order of conditions, and the order of conditions has a treatment plan, and he has to follow even more rules than would ordinarily be in a facility because he has an order of conditions, and if he doesn't follow the rules, he gets sent back. And also, the patients in the non-secure facilities can be pretty dangerous, like David B. In the case, David B. was in the non-secure facility for 25 years. It's not like you have a foot out the door if you're in the non-secure. He was in the non-secure for 25 years, and he didn't think he had a mental illness and refused to take medication. And also Richard S., the other person in David B., had been in for like more than a decade, and he'd been transferred back and forth a few times. He was plotting to exact revenge on a Queens DA, and he's a non-secure. And this court in Glen B. Found that Glen B. had volatile behavior, no remorse, took no responsibility for trying to kill his wife, and that was dangerous for a non-secure. In a secure, the cases that are cited in all the briefs, the patients are volatile, they're threatening, they rape other patients. That's not Sammy M. Sammy M. has done everything he's told. The records are replete with evidence that he would continue to be this way.
Excuse me, counsel, as I read Dr. Lamb's testimony, he opined that Sammy M. continued to demonstrate persisting command auditory hallucinations and paranoid delusions, which he was suffering from at the time he attacked the imam. Is there anything in the medical records that would serve to undercut that expert opinion?
On page 300 and 309 of the records, he says that not taking his medication made him dangerous and made him hit the imam with a hammer. When he doesn't take his medicines, he becomes violent and acts dangerous. And he's not acted, the records are replete. If he's having command hallucinations, he's not acting on them. He's not acting violent. And there is no reason that he would act any different if he stays on his medication. That's what the record shows. Thank you.
Thank you. I'd like to use my 1 minute, if I may, to just briefly address the trial court's findings.
Before you do that, I just want you to start where counsel left off, which is that he, when he takes his medication and, well, one, has he been compliant with taking his medication? Is there any evidence that he's not compliant on a regular basis?
I mean, there was evidence.
Just a minute. To not taking his medication, and then when he's compliant, is he ever dangerous? I mean, I'm sorry, when he's taking his medication, has there been any exhibition of danger, even though he has had, you know, these hallucinations or thoughts about God and about the imam, etc.
Okay, so first off, the last non-compliance I'm aware of was November 2018. There was a spitting incident of medication, and then he was monitored for cheeking after that. As to the other point, I just want to emphasize that George L. George L. said that violence and dangerousness are not codeterminists. And the fact that he hasn't displayed violent activity recently while taking his medication does not mean that he's no longer dangerous, because he could decompensate in a
But there are dangerous people in in the lesser category, less secure category. There are dangerous people there. This is extreme dangerous or extremely dangerous or extremely violent. That's what we're looking for the more secure facility.
The statute refers to the track 1 as danger to self or others from physical harm, and track 2 refers to danger from self from inability to understand one's welfare, be able to take medication like that. So here we're definitely talking about danger to others based on his symptoms and prior acts and lack of therapeutic progress and lack of a relapse prevention plan.
Counsel, I just have one quick question for you, if I might. I think that the Sammy attorney says that the evidence that supports releasing him is in the medical records, right? But Dr. Lamb had those medical records, correct? He read the same records that Sammy M is relying on, and he came to a different conclusion, correct?
That's correct, and I'd just like to emphasize—
And that conclusion wasn't disputed by any other medical or expert testimony, right?
That's correct.
Okay, thank you.
Thank you.
Thank you all. Summit Development versus Hudson Meridian.
Good afternoon, if it may please the court. John Master Pietro for Summit, the plaintiff, appellant, respondent. I want to go right to change order 24. This is the first change order that the court found to be willful. And this is all, these events are all before this lien was filed. Hudson engages an engineer to look at the scope of work. Hudson advises the owner that this is extra work. Hudson tells Summit to proceed. The engineer indicates this is extra work. Hudson signs 28 change order tickets with Summit for the extra work. Hudson's president emails the president of Summit and says, "We are going to pay you for this work." Hudson sends to the owner and the architect a letter saying, "We're seeking mediation." Hudson then issues a notice of intent to terminate my client after they substantially performed. Lower court found that. My client files a lien. I ask you to step in the shoes of my client and say, did they think this was extra work? The lower court, I think this comes down to one or two sentences when finding a willful exaggerated lien. The lower court said Mr. Fakiris was fully aware this was not additional work. This is typical for all these change orders. They're signing change order tickets. It actually says change order. They're saying you're going to get paid. They're saying we're going to go to mediation. This is all before the lien is filed. The owner, Hudson Meridian, and my client go to mediation. My client gets thrown out of the room, and the owner and Hudson Meridian settle for a substantial sum. There's no dispute in this record that that was solely for my client's work.
And it's your position that your client is due that money?
They're trust funds. It would be a violation of 3A. I don't know what the lower court was thinking. The contract between the owner and Hudson Meridian says you have to pay your subcontractors. To say otherwise, it's a violation of 3A of the lien law. Those are funds held for the sole purpose to pay the people that did the work. And I'll wrap this up real quick. The very same argument that Hudson's trying to make to wipe out this entire award. My client went through 12 years of litigation. We went through a 3-month trial. The Supreme Court got most of this right, and I ask this court not to wipe out the entire award on a willful exaggeration lien. This is so far removed from any of the handful of cases that say a willfully exaggerated lien. This is not fraud. This is not billing for work on another job. The contractor and the subcontractor were hand in hand, supporting us. Just because the attorney 8 years later says something different in court, look to see what happened during the actual case. And one last point, we have the insight of the judge, Judge Cohen, the 4404 transcript. My intent and purpose was clear. This is when Hudson's trying to get the full penalty to wipe out the award. With respect to imposing any additional damages or offsets to Hudson as a result of the exaggeration of liens, it was my assessment both in law and equity that any additional assessment of either penalty or legal fees would be inappropriate.
Thank you.
Thank you.
Langomez versus the City of New York.
Good afternoon. May it please the court.
Afternoon.
Casey Okoli for the appellant. Because we submitted a reply brief which addresses the points in the opposition and the fact that there is no respondent here, I would spend my time responding to any questions that the court may have in terms of clarification or further elucidation.
Any questions? Thank you, sir. If you have the statement you wish to make, we'll hear it, but we have no questions.
Thank you very much.
Okay, thank you. People versus Tavon Johnson.
Good afternoon, Your Honors. Tabitha Cohen of Counsel to the Office of the Appellate Defender on behalf of Tavon Johnson. We are starting from a place where everyone is in agreement that something went wrong in the
So
court's...
they're in agreement and they concede that YO, it has to be sent back for YO consideration, and that should be put on the record at sentencing. Right? The people concede?
Absolutely.
Okay.
The prosecution has conceded that the court below failed to follow proper Rudolph procedures. Therefore, the only question before this court is what the remedy should be. And
You disagree that it should be remanded. You want us to make that decision.
exactly. This court should intervene and correct this injustice by directly adjudicating Tavon a youthful offender, as opposed to sending it back down to the court below for resentencing.
But isn't the court below in a better position than we are to make that determination as to whether, irrespective of whether he qualifies to be a youthful offender, as to whether the court is going to grant him youthful offender status?
This court has before it a comprehensive record with thorough mitigating materials submitted by defense counsel in the lower court, outlining all of the ways in which Tavon's case is deserving of youthful offender treatment. In particular, the mitigating materials outline Tavon's difficult upbringing and his growing up in poverty in housing projects in Harlem, while his father was incarcerated when he was a toddler for manslaughter for 20 years. This court has held on multiple occasions that youth like Tavon, that teenagers like Tavon are deserving of youthful offender treatment directly on appeal, as opposed to sending it back down for resentencing. In particular, in the Patrick T. case, in the Stephen B. case, in the Maria M. case, this court has directly adjudicated teenagers like Tavon as youthful offenders, because sending it back down will only perpetuate this injustice even further by delaying the ultimate youthful offender determination. Where Tavon was 16 years old at the time of his 2016 arrest, he has been serving years in an adult prison with an adult sentence without ever having received a proper youthful offender hearing. And so sending it back down will only further delay his receiving a proper hearing where the court can intervene now and correct this injustice, as it has the power to do.
Thank you.
Thank you.
Yeah.
Good afternoon, Your Honors. Michael Yetter for the people. It's quite clear that the defendant is entitled to a youthful offender adjudication at a resentencing proceeding, as we've conceded in our brief, and as is required under Rudolph and Middlebrooks. My only purpose in being here is to oppose my opponent's argument that this court should, in the first instance, make that adjudication. I think the record below is quite clear that Justice Bybin did consider youthful offender treatment in this case. However, she did so at the wrong time. She did so at the plea proceeding. That's a violation of Rudolph and Middlebrooks. We'd ask you to remand for a resentencing proceeding where there can be an express determination. Unless the court has any questions, I'll rest of my brief.
Thank you.
Thank you.
Your Honors, as stated, this court has the authority to correct this injustice and to directly adjudicate Tavon, both an eligible youth and a youthful offender, under the youthful offender statute. And this court should exercise that power in Tavon's case, as it has in other comparable cases, and as there is ample precedent to do. Thank you, Your Honors.
Thank you. Thank you both. People versus David Malowich.
May it please the court, Robert Dean for David Malowich. This case is an example of how even a very good trial judge can make a mistake. Prior to the start of jury selection, the defendant complained about his lawyer. He didn't want this lawyer to represent him. The judge was unimpressed. Okay. The defendant never asked for a new lawyer. He never asked for a postponement. He never asked for an adjournment. He never said he was not ready for the trial to proceed. What he did do was ask to go pro se. And this was clearly understood by the judge who made a ruling. And the judge said, well, you can't go pro se because the only reason you want to go pro se is that you want a new lawyer at this point, so make the best of it. And then when the defendant continued to protest, the judge said, you can appeal this ruling to a higher court, but that's the ruling. So the judge just misinterpreted what the defendant was asking for. It was a mistake, but that's what happened. So we're asking the court to reverse the conviction and grant a new trial.
Anything do you want to say about the sentence? I understand that it goes against your request for a reversal, but...
Okay, well, okay, as an alternative, those extra 6 months that the judge tacked on to the minimum is completely, is not appropriate in this case. Those extra 6 months serve absolutely no purpose whatsoever. It's not deterring the defendant from addictive activity. It's not serving as a warning to other addicts. It's not justified in a case where the defendant was convicted of a nonviolent, purely possessory drug offense due to his own addiction. Those extra 6 months are just a trial penalty for a man who went to trial and got acquitted of the top count. So those 6 months serve no purpose, and I ask this court to reduce the sentence to 3.5 years.
Thank you.
Good afternoon, Your Honors. May it please the court, Jillian Lewis for the respondent. Your Honors, defendant's solitary request to proceed pro se was not a clear and unequivocal request. and it was overshadowed by the litany of baseless complaints. Here, the defendant
Counsel, is the defendant instructed on the law and the clarity with which he or she needs to make this statement to go pro se prior to going into the courtroom?
I'm sorry, will you repeat that question?
I said, is the defendant instructed on the law and the clarity with which one needs to request to go pro se before entering the courtroom?
No, Your Honor. However, here it was clear from his multiple complaints that what he was really complaining about was the trial proceeding, the fact that his attorney hadn't had the opportunity to speak with him, that he hadn't spent enough time speaking with him.
But what he really said was, given all of those things that you've said, it's true, he said, I want to go pro se. He did say that clearly.
Your Honor, yes, he did utter the words that he wanted to go pro se. However, it was sandwiched in between complaints about his attorney. He said that the attorney had not made any motions on his behalf, even though they had just had hearings about, based on the motions that defense counsel had made. He complained that he didn't return his phone calls, didn't return his parents' or his family's phone calls. And it was clear that these requests, that the request was made in a litany of complaints and didn't show the unequivocal prong that he needed in order to proceed pro se and have the court further inquire. So, Your Honors, here the court acted appropriately in dismissing defendant's complaints about proceeding pro se and continuing to trial. This occurred on the eve of trial. The jury was there. They were about to be impaneled. And in fact, throughout the rest of the trial, defendant never made any further complaints.
So he did make several complaints, but the statement is not confused with those complaints when he says, he says again, I don't want Mr. Grosshorn representing me at trial. I will go like pro se. I don't want him representing me. I'll go pro se. I mean, isn't that usually the case, that a person doesn't want the person representing them, or there's some kind of conflict and they determine that they would prefer to represent themselves?
Yes.
A person doesn't usually walk into the courtroom and just say, I want to go pro se. It usually is because they're standing there with attorney and say, I would prefer to represent myself. I don't want this attorney. I want to represent myself.
Yes, Your Honor. However, I think the record as a whole is clear that this statement that defendant made was out of frustration about the fact that he would be proceeding with Grosshorn.
Well, there's always frustration when it's made. I mean, I don't. So one can never complain about an attorney in the same court appearance that they ask for to go pro se? Is that what you're saying?
No, that's not what I'm saying. They can, however, when it's coupled with all of these other baseless complaints, as defendant did, it does not show
Which one is baseless? The fact that he was 9 months and the attorney never visited him? Or the fact that the attorney's family had been calling and there were no return phone calls? Because if true, those are things that people end up calling the disciplinary committee for and saying, never returns a phone call. Yeah.
Yes, Your Honor.
Or is it that he didn't know that he could wear his civilian clothes to come to court because, as he claimed, my sister was calling and they never responded. So he was actually there the day for trial or for jury selection in prison, in the prison garments. I mean, are you saying that those are baseless claims he's making?
No, Your Honor.
Which ones were the baseless claims?
The baseless complaints included the fact that he said my counsel was denying may I continue?
Sure.
That he was denying all his requests for motions when they had just had a hearing.
Okay, well, that's one.
On the motion.
One.
And he said that he said that his attorney had never spoken to him. However, he denied all of the motions that he wanted to make. And the court inquired, how did defense counsel know the motions that you wanted to make if you said you had never spoken to him? And defendant noted that he had in fact spoken to his attorney at the last court part and discussed those with him.
That's right, the last court appearance, but he was saying that in the entire rest of the time, he's never spoken to me. So that was at the point, I think, right before the hearing, right?
Yes, and one...
So his claims, in other words, were hardly baseless that he was making. I mean, they weren't all baseless, as you say, and he made those, and then he asked to go pro se, right?
Your Honor, all of them combined show that he was frustrated with the process and that he was at a point that he no longer wanted to work with his attorney. He said he didn't trust his attorney. And one note about the clothing, although Justice Dwyer did give defendant the opportunity, didn't bring in the jury panel that day, the next day when defendant did show up with clear notice on the record that he had the opportunity to wear civilian clothes, he again chose to not wear civilian clothes. So that goes to show that he was just complaining for the purposes of delaying, and they were baseless.
Counsel, I know your time is way up, but I have to ask this. Before trial, the defendant was made an offer, given the opportunity to plead guilty and get a promised sentence of 3.5 plus 2. Is that right?
I believe so, yes.
And then after trial, when asked for the people's position as to sentencing, what I have here is, quote, to impose in its discretion something more than the minimum sentence. Is that right?
Yes, Your Honor.
Why is that?
Because the offer at the plea agreement reflected what many plea agreements do, a reduced offer. And here, after the trial, the people took into account, just like Justice Dwyer did, the long criminal history of the defendant, his over 10 convictions in New York
Surely
City.
you took that into account when you made the plea offer.
Sure, yes. It's not unusual for two for sentences to be different during initial plea discussions, and then a sentence to be different once defendant is pled guilty. Additionally,
right, but in this case, the people just said, you didn't take a position, right? You just said, Judge, as long as it's more than the minimum. And I just find that troublesome. Why is that?
Your Honor, I believe that's reflective of the plea bargaining agreement and how those offers are typically reduced from what people see after a trial.
Thank you.
Thank you.
I have nothing else unless the court has more questions.
Thank you. Thank you both. Strilchuk versus Hergoian.
Good afternoon, Your Honors. May it please the court. My name is Christopher Dooley from Sir Tillman Balin Adler Hyman for petitioners appellants. Your Honors, we're here on petitioner's preliminary injunction motion to involve the illegal election by the respondents in an attempt to seize control for this non-for-profit charitable organization. As a result of their conduct, they are attempting to take over the building in the East Village, which is owned by the organization, frozen bank accounts, threatened tenants who did not give them money with eviction, and threatened and risked the very ability of this charitable organization to function. Their opposition to this motion does not provide any basis for this court to reject this motion, as the plaintiffs clearly have satisfied all the requirements for a preliminary injunction.
Well, but wasn't part of the problem here, if not a very large part of the problem, the fact that nobody seemed to be able to present to the court a
bylaws,
authenticated, signed, clear copy of the bylaws of this association? You, I believe, someone presented them in English, somebody else presented them in Ukrainian. None of them were signed. They were out of order. They were not paginated. They were not verified. How is the court supposed to figure out what are even the requirements relating to the special meetings and all those things that, come into your
Certainly, Your
claim
Honor.
against the election.
I understand, and there's an important distinction to be made there because the only party that has submitted firsthand knowledge of the bylaws was the appellants. There were several affidavits which provided the bylaws to the court.
But nobody presented a signed set of bylaws, did they?
Well, they provided bylaws and stated that these are the official bylaws, and only the appellants did that, Your Honor. The respondents only provided them by way of an affirmation saying, no, these are
the bylaws.
These are the official bylaws. Yes. And what the court did and what the court erred in doing was to take an affirmation with no firsthand basis and credit it over numerous affidavits which explained to the court that these were the bylaws that governed. And jumping off that point, Your Honor, an important thing to keep in mind here is that one of the many things that the Ukrainian version and the English version of the bylaws have in common is, among many things, the most important is the notice requirement, that the majority of the branches have to be noticed. That's in both versions of the bylaws. And there is no evidence whatsoever that respondents served notice to a majority of the branches. And in fact, the appellants have provided, I believe it's 23 affidavits, 20 of which or so of which are from the non-parties, explaining that they were never notified, that that's the reason why they did not attend the so-called extraordinary convention, Your Honor. And in fact, several of those were from branches in which the respondents indicated that they had noticed them. So, and it was impossible, given the number of affidavits that were put before the court, for the majority of branches to be notified, regardless of which version of the bylaws the court were to accept. So certainly, the court should have accepted the only one that was put forth with firsthand knowledge before it. And even if the court were unsure at that point as to which bylaws and which nuances of the bylaws to adhere to, the important provisions of the bylaws at that point, at that juncture, were undisputed. So for that reason, the bylaws issue is really should be a non-issue. And Your Honor, I'll just point out that, again, everything that the respondents have put forward was based on information and belief. It said in the first paragraph of the affirmations that respondents put forth. In comparison, the appellants put forth 23 affidavits explaining in detail, ad nauseum, what was at issue here. The appellants made clear the likelihood of success. The majority of branches clearly did not call for the convention. The convention was not timely noticed. The convention did not provide the branches with the sufficient notice, nor was it sent to all the members. Again, the respondents failed to provide any valid opposition to that point. If Your Honors look at the merits and address the arguments raised in opposition, it is crystal clear that the petitioners are likely to succeed. The easiest one to address is the one I've already addressed somewhat. And also, I'll wrap it up here, is that the clear requirement that majority of branches call for the convention, which plainly did not occur.
Thank you.
Good afternoon, Your Honors. Arnold DeJoseph for the respondents. Let me address this bylaw issue first. And that's the main issue in this case. One side says it says one thing, the other side says another. There is no translation in here. The only translation they submitted is by someone that said, I'm proficient in Ukrainian and English, which unfortunately is the same thing the respondents did. So the court was left in the position of going, how am I supposed to decide this? And with all due respect to the appellants, the burden of proof here is so high that they had to know. All they had to do was provide a certified translation. And they didn't do they just didn't do it. So what did they expect the court below to do? Just take their word for it? That's not what's going to happen in a case like this, ever. And it did, and based on that alone, we shouldn't be here. Moving on to this irreparable harm, other than them screaming out, the house is on fire, they have not demonstrated any irreparable harm here. And in fact, by their own admission as to their own conduct prior to this emergency convention, you will see that the house was on fire No conducting elections for 5 years, admitted. They're supposed to do it every 3 years. No filing fiduciary reports once a year. They never did it for 5 years. They have a president that had to resign. He's also the guy that's in charge, that is the credit union, holds the mortgage, and is also the one that's not paying taxes, not doing this, but making sure the mortgage gets paid. So you have outstanding taxes, not filing tax returns. And the problem is, without any affidavits, in their reply, they admit all this. And they come here and go, oh, if someone takes over, there's irreparable harm. Also, the court needs to look at where we are today. Today, we're 2 years into this. There has to be an election in September of next year. And I don't know what they're really seeking here at this point in time, because all this irreparable harm, the organization's still there, the building's still there. At that point, I don't think the court below had any other choice but to say, hey, listen, I'm never granting a preliminary injunction. You haven't demonstrated anything. And the reality is, the best part of this is the guy they want to have be president had his membership revoked. And if you sit here with a straight face and think about that in the record, and they go, yeah, but those were fake proceedings. How is that possible? So at this point, I think the court below had more than ample reason to deny, certainly to deny the preliminary injunction, and then based on that, to dismiss the petition. No questions? Thank you.
Thank you.
I'm going to just very briefly respond to respondents' points. First, the translation issue I submit is a red herring and has been this entire time. The English version of the bylaws, as has been set forth and explained via affidavit, is the official version. There is no need for a translation. In fact, the only person that has submitted what was referred to as a translation was the respondent when he provided the Ukrainian version, which again is not the official
Counsel,
version.
when you say that the bylaws that were submitted were the official version,
correct.
Does that mean that they were never translated? That they were written in English?
I'm sure that they were translated, but the original version, and in fact, I think that counsel provided a version that he may have translated. And I'm not sure how many times they've been translated back and forth, but the version that was set forth is the official version, which has been adopted. So to provide a translation from the official, I think is a red herring for that reason, Your Honor.
And
Also, as to the
counsel, may I ask you, how was that business record authenticated?
it was authenticated by the numerous affidavits who.
And under the CPLR, is that sufficient?
I think if Your Honors look at the affidavits, I think that they were sufficient. In
Aside
spelling.
from saying this is it, are there any other indicia of reliability?
Your Honor, I believe it's all within the affidavits. I wouldn't want to misstate that, but the affidavits went line by line as to, I believe, lays out would meet the authenticity requirements. Your Honor, if I may just briefly respond to the irreparable harm. I see my time is up. I'll be just a couple seconds.
I'll give you 30 seconds.
Thank you, Your Honor. The law is very clear that when governance is rested within an organization or a corporation, it is, as a matter of law, irreparable harm, something which the lower court ignored and respondents continue to ignore. As to the allegations of counsel, I invite Your Honors to look at the affidavits which completely rebutted the allegations which were not admitted in the reply brief as to the conduct of some of the officials within the organization. And finally, there was an election in May 2020, which was done properly. Over 85% of the branches were notified. Over 96% voted the current president and the officers of the organization, which are named plaintiffs. And I think that that is an important consideration for the court. Thank you very much.
Thank you. Thank you both. And last but not least, the people of the state of New York by Letitia James against Lawrence G. Allen and the rest.
Good afternoon, Your Honors. May it please the court, Massimo D'Angelo on behalf of Ackerman LLP.
Good afternoon.
So just as a preliminary matter, regrettably, we had to file a third motion for a stay pending appeal this morning. There were 2 prior stays that were already issued by this court. The last stay in August required the New York Attorney General's office to put the status quo back in place. That still hasn't happened, so unfortunately we had to move again this morning. That's not before your honors yet. So just as a preliminary matter. In this case, the trial court erroneously held that New York State Senate Bill 6536, which increased the statute of limitations period for Martin Act claims from 3 to 6 years, applies retroactively, even though the legislation specifically states that it's to take place immediately. So it's problematic under Regina, that the Court of Appeals ruled, and particularly so because it deals with a substantial constitutional right of due process here. And this court also held...
But isn't it different in a way than Regina? Because in Regina, all the attorneys had been sort of acting, understanding that there was a 4-year look back, and they changed it in Regina. Here, everybody was assuming up until the Court of Appeals decision came out that there was a 6-year statute of limitations. All of a sudden, it got knocked back by the 2018 decision by the Court of Appeals and Credit Suisse to make it a 3-year statute of limitations, which was not how people were, not the way it was seen for many, many years before that. So it's supposed to be remedial. That's what the legislature said. And they acted very, very quickly, definitely in response to the Credit Suisse, and wanted to get it back to status quo. Wouldn't that suggest that perhaps in this particular situation, a retroactivity is what was intended?
I think that's an excellent consideration, but I think that Regina is extremely clear, particularly with regard to due process rights. And in Regina, Regina essentially, as Your Honor pointed out, extended the 4-year prior look-back period to an ad infinitum look-back period. In fact, before Regina, there was almost a freeze on rent-regulated buildings. They weren't selling anymore because of Regina and because of this ad infinitum, no repose. It's a very similar standard here, although the facts of the case are different. As Your Honor pointed out, this case was started in December 2019. Before the case was started in the summer of 2019, that's when they changed the 3-year Credit Suisse statute of limitations for Martin Act claims and extended it to 6 years. But the investigations here occurred far before that. And as early as 2016, the New York Attorney General was involved in these investigations. So it's actually directly on point because Regina specifically states that if there is an intent by the legislature to make the legislation retroactive, it has to be specific in that regard. And there's nothing in the legislation that says it's to take retroactive effect. In fact, if you look at the definition, the plain meaning of immediately, it's right now, as of this moment, and then prospectively going forward, of course, but not in hindsight. And that's even, the error was even compounded by the trial court because the trial court developed at trial, it was the first day of trial, and there was a new theory that was espoused by the New York Attorney General, a continuing wrong theory, which has never been applied in the fraud context. In fact, if this court allows this decision to be upheld, it will upend fraud jurisprudence. There will be absolutely no repose. The continuing wrong theory is analogous to leaving a scalpel in a patient, a doctor leaving a scalpel in a patient to toll the statute of limitations period for medical malpractice cases. And now it's being applied in the fraud context under a trial court decision from 1998, 7040 Colonial Road Associates. Okay, there it was a 59-unit cooperative in Brooklyn, and there was a Fifth Amendment made by the sponsor under that plan. And he made fraudulent statements about the financial viability of the sponsor. So completely different. That case actually dealt with an accrual. It didn't even deal with tolling there. So clearly, and even at the beginning of this trial, on the first day, the judge said, if all the investors here were paid back in full, this case is over. But then the appellants at trial were not allowed to show that evidence. In fact, I took the deposition of both experts. They had an accounting expert and a valuation expert on the Saturday and Sunday leading up to trial. Their accounting expert confirmed that he was actually first engaged by the New York Attorney General in this case to do an analysis on the return on capital for these investors. And in fact, upon further, and this actually came up after 7 hours of testimony, he conveniently remembered that he was first engaged to do this analysis, which we still don't have and was still not produced to us. And we weren't allowed to show it at trial. So there were a litany of errors in terms of what we were allowed to show at trial. And you know, the evidence all shows that there was no fraud here. In fact, all of the investments were done in clear and explicit understanding of what the limited partnership agreement provided for, which was to invest in affiliate entities. It allowed for everything. And the limited partners, they all testified at trial that they read these amendments, they approved them. They approved these amendments. So this is a situation where we have a 2004 fund. If this continuing wrong theory, which was newly minted in this case, is, I'm sorry, I'll just a few more words as I finish up.
Okay.
It will open the floodgates. It's an extremely dangerous precedent. It will open the floodgates and allow investors to sue decades, even centuries, after making the initial investment. Thank you.
Thank you.
May it please the court, Mark Grube for the Attorney General on behalf of the people of the state of New York. The evidence here shows a straightforward case of fraud and breach of fiduciary duty. Allen's transfers to...
What about the last point that counsel just made? That if we do this, it will be extending the statute of limitations for years and years and years after people make their investments, that they still will be able to bring their lawsuits. How do we prevent against that, or is that not a correct statement?
Your Honor, I have several responses to that. First of all, that's not the case here, where the same misstatements that were made in the original offering documents were made repeatedly throughout the limitations period from 2013, 2014, into 2018. They were contained in reports, quarterly and annual reports. So the fact that they made these representations, you know, back when they made the offering documents, I mean, perhaps there might be some case where you would have to guess, but that's not the case here because they continued to make those representations throughout the limitations period. So it's simply not the case that this would extend liability indefinitely. There was voluminous evidence of fraud at the trial and the preliminary injunction hearing that I didn't hear substantively addressed. I'll just briefly cover it before going to the statute of limitations point. There was evidence that Allen had investor funds transferred into his own broker-dealer that his own auditor opined was valueless. And he also took out carried interest, paid himself when he had represented to investors that they would get paid first. And he also took investor funds to pay the operating expenses of his own broker-dealer. But turning to the statute of limitations point, as Your Honor correctly characterized, Regina, the facts there were quite different. In addition to the statute having always been 4 years and then being expanded to 6 years, it also imposed substantive obligations, which is similar to the other First Department case that my friend cites. Whereas here, there's no reliance interest. All the time that all the acts here occurred, everyone understood the Martin Act to be 6 years under this court's precedence. At the time that the complaint was filed, everyone understood the statute of limitations to be 6 years under the statutory amendment. So the legislature simply restored the long-held understanding of the Martin Act statute of limitations. And there's also breach of fiduciary duty claims, which have a 6-year statute of limitations in any event. And this conduct doesn't test the boundaries between New York and Delaware breach of fiduciary duty. It's a clear-cut breach of fiduciary duty as well as Martin Act fraud. I didn't hear anything about preemption, so I'll just rest on the Greenberg case that disposes of that issue. With respect to the procedural arguments, the trial court had ample discretion to manage this complex bench trial as it did.
Do I understand correctly that the judge allowed all of the preliminary injunction evidence to be into the trial, meaning he said, I'll consider it all, whether you read it aloud or you refer to it, it's all part of this, right?
That's correct, and that was pursuant to a stipulation that the parties entered into, allowing the court to proceed that way in a matter of efficiency. And we cited cases, this is not unusual, where parties might stipulate to have a prior trial admitted at a new trial. And in a bench trial, I mean, jury trial might be a different question. In a bench trial, that's perfectly reasonable. The judge doesn't need to sit there and listen to 5 days of people reading testimony. So that was a reasonable exercise of the court's discretion. I do want to address a few other, factual issues that my friend referred to. The first one, I think he talked about this return on capital analysis. Pope never performed any return on capital analysis. The trial court instructed Pope to look at, because the record keeping for this fund was so poor, nobody really knew what interest different investors had. So the court instructed Pope to go and try and figure it out so that we don't need to have a receiver come in, so that we can do this more cheaply. But the problem is that the Pope was not able to make that determination. And still to this day, the receiver is having trouble going forward because of the orders in effect. So we would ask the court to resolve this appeal expeditiously so that the receiver's work to protect the investor assets can move forward.
So let me just ask you one question. Is it your part of your position that the offending conduct took place in 2013, 14, and 15?
Yes. And 16, 17, 18.
The earliest is 2013. So assuming a 6-year statute, that would all be in.
That is correct.
Okay.
There's a section of our brief that just sort of in the statute of limitations, walks through each act and the record sites that occurred during the limitations period. The court doesn't have any other questions. I know there's a lot of issues that are raised in this appeal, and I'd like to, address anything that the court would like me to.
What would follow if we found that it was a 3-year statute of limitations?
Well, for this case, I don't think it would really impact, because as I mentioned, you still have the 6 years for the breach of fiduciary duty. I do think that, it would undermine the legislative intent of, of making the Attorney General the primary enforcer of, securities laws. But as for this case, it doesn't have an impact.
Thank you.
Thank you.
Just a few points here. That's incorrect. If you look at Mr. Pope's deposition transcript, he confirmed that he did that analysis, and all the limited partners were paid back in full, and some even more, and that he did this analysis and he was asked to change course by the New York Attorney General and abandon that procedure. Those documents were never provided, and the appellants were not allowed to produce the documents showing that they were repaid in full. Beyond that, the court relies on a demonstrative, which is Exhibit 85. It's 2753 in the record. And the trial judge just pulled the figures off of here and pasted them into the judgment. Ms. Curta didn't have any firsthand knowledge of the information in the document. In fact, Mr. Pope, the New York Attorney General's expert at his deposition, said he couldn't decipher any of these numbers. He couldn't reconcile anything in here, so he couldn't use it. He didn't know what this was. So, you know, that certainly needs to be corrected. In terms of the trial evidence, as was pointed out before, the transcripts were first supposed to be designated. In fact, we spent an inordinate amount of time. The trial judge even apologized at the beginning of the trial because we had all this testimony that was designated that was supposed to be read into the record, and then midstream, the court decided to just allow all the transcripts in the record.
What difference does that make? I mean, the information was still before the judge who was making the decision. So whether you sat and read stuff that had already been at a preliminary injunction hearing, or the judge said, okay, I'll take a look at everything, how did that possibly hurt your clients?
Well, it was inadmissible hearsay. We couldn't cross-examine a transcript. I didn't handle the preliminary injunction, for one.
But somebody, I mean, there was some lawyer there handling the preliminary injunction on behalf of your clients. They could have cross-examined the appropriate witnesses, no? Or
Correct. And but you know, one of the major things is we subpoenaed Ms. Curta, who prepared this, who the New York Attorney General's own expert said he didn't know what it was, but we weren't allowed to depose her. It was denied. So, I mean, the level of unfairness in this trial was legion. I mean, you know, the trial court even stating you don't need 9 or 10 investors to appear at the trial. This case was already prejudged. It had already been determined. There was no real reason to have a trial, okay? There's not a great deal that I expect to learn beyond which was presented at the preliminary injunction hearing. These are all direct quotes from the record. And exclusively quoting from the PI hearing, I had the expert, I was cross-examining Mr. Dolgoff during the trial. And Mr. Dolgoff, one of the big parts of this case is whether this NYPEX pioneering online electronic system which lines up investors in the secondary market of this private equity fund is a revolutionary platform. And Mr. Dolgoff, by the way, has never appraised any company. He's a wrongful termination damages expert. He's never even done evaluation before. He didn't know if NYPEX was worth 0 or $1 billion. But while I had him on the stand during cross-examination, the judge asked him, do you know the accounting method CISO? And Mr. Dolgoff and I both looked at each other befuddled. We didn't know what that was. And then the judge turned to him and said, it's shit in, shit out. So that's what we were dealing with at this trial the entire time. It was already prejudged. And, you know, we believe that certainly this court has the opportunity to today solidify Aguiza and Regina and rid the court of a continuing wrong theory which would completely change our fraud law and preempt. There should be preemption with regard to securities laws under the Martin Act.
Thank you.
Thank you.